I've got a question about trademark record and its first use in commerce. I'm the manufacturer. I produce some goods and have registered mark in my country. I'm guessing not the US. So the question is, if someone will start selling products, not their products with my logo, but my products on the territory in the US, who will have the priority over my trademark? This person who began selling it commercially by selling my products for me, because it's my product and all the info about the label is about more and more. Okay, did you get enough on that?
Yeah. So
Okay.
this seems like this individual, to frame it up right, let's just say they're in the UK, they have a product, they have a trademark in the UK, and someone's buying them and selling them in the United States and kind of claiming to be them, right? Who's got priority of use in the United States? Well, technically, like this third party is the one using the trademark in the United States, but they don't have any trademark rights because they don't actually own the trademark or the brand, right? If they were to, go to the USPTO and say, we're this company and this is our brand, well, they're committing fraud on the USPTO by doing so, because those products are not their products, right? They're a third-party reseller of those products.
Ooh, that's cool. Interesting. Okay.
Yeah,
so you're saying real quick, so the person selling, if they're putting their brand on, they're sort
if they're putting their own brand on this third party's products and selling in the United States, that's fine. Right?
Okay.
But for my money, I would say that taking someone else's products from a third party country and then claiming to be that company here in the United States, that's fraud on the USPTO to move forward with an application. That's how I would pursue litigation against this company. Would be, we'd file our own trademark application in the United States on behalf of like the UK company, right? And then if we had to, we'd pursue litigation against the third party in the United States claiming to be the company that sells those products. That's how I go about it. It's a little complicated, right? Because at the end of the day, you get rights based on use in commerce here in the United States. So if you're selling products in the United States, if you're offering products or services for sale in the United States, technically you have first use of that product or name. But if you're holding yourself out to be a third party or a company that you're not, that's fraudulent behavior, and the USPTO doesn't look kindly on that.
Perfect. Thank you, Matt. Can you explain the difference between a patent pending and a patent issued?
Yeah, so a patent pending is, you can say patent pending when you have a patent application on file, when you filed a patent application with the USPTO. So that can be either a provisional or a non-provisional. Once you have that on file, you can say patent pending. A patent issued is only at the very end of the process. When you filed your patent, the patent office has examined it, and then they've actually issued you a patent. That's when you can say, that's when you have an issued patent. Kind of similar to trademarks, right? The difference between the encircled R and the TM symbol. Yeah.
Yep, that's exactly right. We tell clients when they get that application serial number, even before we even apply for the trademark, they can use that TM symbol, but they can only use that circle R symbol when they receive an actual registration number from the USPTO, which typically is about 14 months after the application.
Can take a bit.
Yeah.
Right.
Yeah, it's crazy how long it's been taking these patents and trademarks to get through. Despite the USPTO hiring 800 patent examiners this last year, something like that. Yeah. And like another 100.
Yeah, I've heard 800. I've heard they have over 8,000 examiners now.
That's a lot.
Yeah. So on the patent side of things, it's typically it'll typically take you several years to go from patent pending to patent issued. Sometimes longer. If you're in a hot technology area like AI, it's probably going to be even longer than 2 years.
I will say though, we have had some success with fast track, track one, and first time filer applications getting to the front of the line.
Cool.
Seen patents get filed and issued in the same year. Not saying that's going to happen for everybody, but there are ways to expedite and get it done fast. But by and large, you're right on, Troy. That's exactly what I've experienced too.
I wish we had that fast track at the on the trademark side. They
should. All they gotta say, inventors pay us a couple extra grand, and we'll put you to the front. That's a great moneymaker. I'll pass that along to.
Yeah. They should do something like that. The closest thing we had to that was like during COVID. If you had like a COVID related product or service, right, and you could, try to get to the front of the line, for circumstances essentially.
How can I be sure infringing a patent?
This is great.
Well, that's
Money.
a great question.
Hire
Even
Troy.
judge-
Talk with an
Yeah.
attorney.
Even
Barrel-
judges aren't sure sometimes, right? But yeah, so to know if you're infringing a patent, or to at least assess whether you're infringing a patent, you want to look at the very end of the patent, and that's where you'll find some numbered paragraphs. We call those claims. And what you need to do to determine whether you're infringing a patent is you need to go through those claims element by element, and you need to compare the claim to your product. And your product has to match up with every element of the claim. Has to be a one-to-one correspondence as you go through the claim. So if your product is missing an element that's called for by the claims, so say the claim, just very simple example, a pen comprising a tip and an eraser, and all you have is the eraser. You don't have a tip. That means you're not infringing that claim. One common misperception is sometimes people will think if you add something to your product that's not in the claim that you can avoid the claim. That's actually not true. So if the claim calls for A, B, C, and D, and your product has A, B, C, and D, but it also has E, you're still infringing that claim. So when you wouldn't infringe the claim would be if the patent calls for A, B, C, D, and all you have is A, B, and C, but you're lacking D. So that's how you would know. But I would encourage you to seek out counsel on that, because it can be a pretty involved exercise sometimes to make those determinations.
I'm confused about how many category codes I need to pay for. I want to trademark a logo to be on artwork, to use a print on-demand service for placing art onto products, like mug, t-shirt, tote bags, kind of swag. They sell artists for paying commission. I'm not associated with manufacturing process of a product and not using a logo as a brand identifier like Nike. They go on to say, they're not using a logo like Nike. I not expected more than just a trademark for the logo under code 16 for art applications to be associated with me. Thoughts on that, Matt?
Yeah, I got it. So they're getting a little lost in the trees here. When you think about like what your business does, right? You can be a product business or a service business, or maybe even both. This individual is a service company, right? They're taking people's desires for branding products and they're placing their product logo on the product. They're not actually selling mugs, t-shirts, posters, anything like that. They're a service company.
Yeah.
And so, if you're branding products for other people, you could conceivably be, if you looked at it just at face value, it could be like in 8, 9, 10 different classes of products at the USPTO. But that's not the trademark that they're offering their customers. The trademark or the service that they're offering their customers is basically printing services on behalf of third parties, right? So it's a single service that they're offering, right? They're not selling mugs or t-shirts or whatever. They're just offering this service of basically printing products for customers, maybe drop shipping them. In which case it's pretty simple. It's just a single class 35 application. Class 35 is business category at the USPTO. It does anything from online retail store sales to business services. I would assume that most of what they're doing is going to be in class 35. So
that's awesome. That's a great answer, Matt. It doesn't matter what product they slap their client's product on.
Yeah, because at the end of the day, consumers aren't buying the mug from them. They're buying the service that basically brands, or prints the product for them, right? So that's what they're offering their clients. They're not offering their clients t-shirts. The way that I think about that too is, where does the client make their money, right? When their client pays them the money, they're not buying the mug really, right? They're buying the service that puts the art on the mug. So it's probably just a single class application at the USPTO. Consumers aren't buying the mug from them. They're buying the service that basically brands, or prints the product for them, right? So that's what they're offering their clients. They're not offering their clients t-shirts.
What types of products and ideas are processed faster. So is there such a thing of that, Troy? Have you noticed that certain technologies?
Yeah, for sure. And, it often corresponds with, what's hot in the news that you see. For instance, right now, AI, artificial intelligence, which it kind of took over for blockchain, that used to be the hot technology. In the patent office, patent applications get assigned to examiners, based on the examiner's area of technology. So when you've got tons of applications being filed on AI-related applications, for instance, the number of examiners in that area doesn't necessarily increase. So you've got the same number of examiners that have a ton of applications to examine. So in very hot technologies, the applications tend to get processed slower, just because the examiners are overwhelmed and they have very large queues of applications. And unless you do something like a request for accelerated examination or some kind of petition to make special, then your application is just going to get examined in the order that it was received. So you go to the bottom of the pile or the top of the pile.
Right.
Yeah, but on the other hand, if you're filing an application in a relatively, an area of technology that just doesn't see so much inventive activity going on, then your application is going to get examined a lot faster.
Question for you, Troy. This kind of relates to what we see on the trademark side. So on the trademark side, if I have a client who's got some pending trademark applications at the USPTO, and say they've been around for 6-7 months pending at the USPTO waiting examination, and we submit a third application, a lot of times that third application is going to get reviewed with the first two. If it's in the same field, I assume that it's going to get assigned to the same examiner, and he or she might decide to just do all three at the same time. Do you ever see that on the patent side?
I don't see that so often. No.
Okay.
Now I've seen that in the trademark side also. But no, I have not seen that in the patent side. What will happen though, if you have a pending application and you file a continuation application of that, the continuation application is basically a new application, for anyone who doesn't know. It's basically the same application that you refile, but you're seeking different types of claim coverage. So you'll have initial application, you'll get one kind of claim set, and then you'll decide, my claims aren't really broad enough, or I want to cover a different aspect of my invention. So then you file what's called a continuation application, which is you have the same description, but you're changing your claims, and you get to go all the way back to your initial priority date. So for those kind of applications, often they will get assigned to the same examiner, and you will see examination happen more quickly. I'm not sure why. I can only assume because the examiner is already familiar with the application, and it's something they can get off their plate pretty quickly because they have that familiarity. I don't know if there's a formal process in the patent office where, I don't know exactly how that happens. I've actually tried to find out, because we've had situations where we actually want to get the application assigned to a different examiner.
Yeah, there's a couple trademark examiners at the USPTO. When I see their name come up on an office action, I just knock my head against the floor.